In this video, I'm going to break down exactly what makes a contract legally binding in Florida. I'll also reveal the 3 critical mistakes that destroy contracts before they even begin and show you 2 real Florida cases that will completely change how you think about business agreements. By the end of this video, you'll know more about protecting yourself in contracts than most people learn in years of expensive legal battles. So you'll definitely want to stick around. I'm Santiago Cueto, board-certified international business law expert and best-selling author. And for nearly 30 years, I've watched the same contract disasters play out over and over again. The good news? They're completely preventable when you understand the rules. Now, here's the thing about Florida contract law that most business owners learn the hard way. One small mistake can cost you hundreds of thousands of dollars and months of legal headaches. I've seen successful entrepreneurs lose everything because they didn't understand how contracts actually work in the Sunshine State. Let's start with the foundation. Florida follows what's called the common law approach to contracts, but with some unique twists that can catch even experienced business owners off guard. For a contract to hold up in a Florida courtroom, you need 4 essential elements, and missing even one can make your agreement worthless. First, you need an offer. This isn't just someone saying, "Hey, want to do business?" It has to be specific, clear, and definite. In Florida courts, vague offers get thrown out fast. The offer must spell out exactly what's being promised, when it's being delivered, and what the other party needs to do in return. Second, there must be acceptance. And here's where Florida gets interesting. The acceptance has to match the offer exactly. If someone offers to sell you their downtown Miami office building for $75 million and you respond with, "I'll take it for $74.5 million, you haven't accepted their offer. You've made a counteroffer which legally kills their original offer. Third, you need consideration. This is legal speak for both sides have to give up something of value. It doesn't have to be money. It could be services, goods, or even a promise to not do something. But here's the Florida twist. The consideration has to be adequate. Courts won't usually question whether you've got a good deal, but they will question whether there was a real exchange of value. And finally, both parties must have the legal capacity to enter into the contract, and the agreement must be lawful. This means no contracts with minors, no agreements made under duress, and definitely no contracts for illegal activities. Now, let me tell you about the 3 mistakes I see destroy contracts in Florida courts every single day. These aren't obscure legal technicalities. These are preventable, avoidable mistakes that cost real people real money. Mistake number 1 is the deadly assumption that verbal agreements don't matter in business. But here's the truth. Verbal contracts are absolutely enforceable in Florida, but only if they don't fall under the statute of frauds. This state law requires certain types of contracts to be in writing, including any agreement that can't be completed within 1 year and any contract involving real estate. I've watched business owners learn this lesson the hard way when they tried to enforce a handshake deal for a 2-year consulting arrangement, only to discover it was legally meaningless because it wasn't written down. The second mistake is even more dangerous, assuming that signing a contract means you understand what you're agreeing to. Imagine you're sitting in a Miami Beach restaurant, shaking hands with a potential business partner over a multi-million-dollar deal. No paperwork, no lawyers, just your word and theirs. Now fast forward 6 months and you're facing a lawsuit because that handshake agreement just fell apart in spectacular fashion. Florida courts take a hard line approach on this principle. They operate under the rule that if you sign it, you're bound by it, even if you didn't read or understand it. There's a famous Florida case where a business owner signed a lease agreement without reading the fine print and ended up personally guaranteeing not just his lease, but every other tenant's lease in the entire shopping center. The court's response? You should have read it before you signed it. The third mistake is the most expensive one, failing to include proper dispute resolution clauses. When contracts go bad in Florida, they often end up in litigation that can drag on for years and cost more than the original deal was even worth. Smart contracts include mediation clauses, arbitration agreements, and attorney's fee provision that can save both parties massive headaches down the road. Let me tell you about a real case that perfectly illustrates how Florida contract law works in practice. A Miami tech entrepreneur entered into a private jet leasing agreement that included a clause allowing the aviation company to provide a comparable aircraft if the specified jet wasn't available. Now, after 3 weeks, the company started substituting older, smaller aircraft, claiming maintenance issues, but the entrepreneur discovered that comparable aircraft was defined entirely by the aviation company's judgment, not industry standard. The case went to Florida court, where the judge had to interpret what comparable aircraft actually meant under the state's plain meaning rule. The court found that the language was ambiguous because it didn't specify who would make the determination or what criteria would be used. The judge ruled in favor of the entrepreneur, but only after months of litigation that cost both parties far more than the original lease payments were worth. Now, before we dive into our second case study, I want to ask you something. If you're finding this information valuable, and you can already see how understanding these principles could save you serious money in your business dealings, do me a favor and hit that like button right now. And if you want to make sure you never miss content that could protect your business interest, subscribe and ring that notification bell. Trust me, the next case study is going to show you exactly why these details matter so much. Now, our second case involves a construction contract gone wrong in Boca Raton, and it demonstrates one of Florida's most unique contract law principles. A property developer hired a general contractor to build a small office complex with a firm completion date tied to a major tenant's move-in schedule. Now, the contract included a penalty clause, $50,000 for every week the project ran late. Everything seemed to be going smoothly until Hurricane Irma hit Florida. The construction was delayed by 6 weeks due to the storm, supply chain disruptions, and mandatory evacuations. When the project finally finished, the developer demanded $300,000 in late penalties. The contractor argued that the hurricane was an act of God and shouldn't count against him. Now, this case hinges on a principle that Florida courts take very seriously: force majeure clauses and the doctrine of impossibility. Florida law recognizes that sometimes performance of a contract becomes impossible due to circumstances beyond anyone's control. However, the courts are very strict about what qualifies. The interesting twist in this case was that the original contract actually included a force majeure clause, but it was poorly written. It mentioned natural disasters, but didn't specifically include hurricanes, and it didn't clearly excuse delays. It only excused complete inability to perform. Now, the Florida Appellate Court ultimately ruled that hurricanes do fall under natural disasters, but since the work could still be completed, just delayed, the contractor was still liable for some of the penalty. The contractor ended up paying $150,000 instead of the $300,000, but the case dragged on for 2 years and cost both parties more in legal fees than the original penalty amount. This case perfectly illustrates why specific, detailed contract language matters so much in Florida courts. So how do you protect yourself when entering contracts in Florida? Let me give you 3 specific strategies that can save you from these expensive disasters. First, always include detailed definitions for any subjective terms. Words like reasonable, satisfactory, comparable, or best efforts should be defined with specific, measurable criteria. Don't leave room for interpretation if you can help it, because Florida courts will enforce whatever interpretation seems most reasonable based on the plain language of the contract. Now, second, you should include comprehensive force majeure clauses that specifically address your industry's common disruptions. If you're in construction, mention hurricanes, supply chain disruptions, and permit delays. If you're in tourism, address pandemic restrictions and travel limitations. Florida's unique climate and economy create specific risks that standard contract templates might not cover. Third, always include attorney's fees clauses and alternate dispute resolution requirements. Florida law allows contracts to specify that the winning party in any dispute gets their attorney's fees paid by the losing party. This can be a powerful deterrent to frivolous lawsuits, but can also make legitimate disputes much more expensive if you lose. Consider requiring mediation before litigation, and for smaller disputes, mandatory arbitration can save massive amounts of time and money. Just make sure these clauses are written properly, because Florida courts will enforce them exactly as written. The bottom line is this: Florida contract law rewards preparation and punishes assumptions. Every handshake deal is a potential lawsuit. Every unsigned agreement is a potential disaster. And every ambiguous clause is a potential fortune lost to legal fees. The two cases we looked at today resulted in hundreds of thousands of dollars in combined legal costs and delays, all of which could have been avoided with better contract drafting and a clear understanding of Florida law. As someone who's guided countless businesses through these exact situations, I can tell you that knowledge truly is your best protection. If this breakdown of Florida contract law helped clarify how you can protect your business interests, I'd really appreciate if you can give this video a like. It helps other business owners find this crucial information. And make sure to subscribe to my channel for more practical legal insights that can save you serious money and legal headaches. Remember, when it comes to contracts in Florida, precision isn't perfectionism, it's protection. See you in the next one.